United States of America, President Barack Obama.
Good to see you. I just want to say everybody back home, right back at you. We appreciate you. You always give us straight talk.
And welcome to Straight Talk. Well, today, Pastor Anthony Williams and I are highlighting the person that's going to be the next Supreme Court judge from the County of Cook. Supreme Court Justice P. Scott Neville.
Good afternoon to both of you, to UWL and to Pastor Williams.
Look here, I just want to shake hands with history. And WL, Illinois Supreme Court.
Right.
Illinois, and that's a big thing.
Okay. What I'm going to do is talk about his past. He went to Forestville Grammar School in Chicago, DuSable High School in Chicago, Colville Stockton College, Washington University School of Law, Sixth Grace Presbyterian Church.
Right.
You go to church, guy?
I go to church.
You mean you're a good Presbyterian?
Even though there's a separation between church and state in the Constitution, on Sunday,
right,
at my house, we go to church at my house.
Okay, Anthony, go ahead.
Let me share the distinguished Judge Neville's experience. He has 45 years as a practicing attorney and judge, elected to the Circuit Court in 2000, appointed by the Illinois Supreme Court to the Appellate Court in 2004, elected to Appellate Court in 2012, appointed by the Illinois Supreme Court to the Supreme Court June 15, 2018, authored over 1,400 opinions, including Rule 23 orders, summaries, orders, and dissents. Chicago Daily Law Bulletin has written over 180 articles highlighting Justice Neville's decision. And this is quite a body of work you going on.
Right. And judge and guest lecturer at Loyola's Law School. Mentored law students from DePaul University, Loyola, and John Marshall, and University of Chicago Law School of externs. You have to forgive my glasses; they don't work right.
Well, here let's look at his leadership experience. Yes. This is why people need to hear the body of work of this great judge. Past chairman of Illinois Appellate Court, First District, Executive Committee, past president of Cook County Bar Association, past chairman of the Illinois Judicial Council, co-founder of the Alliance of Bar Associations, annually since 2000, provided two law schools. He provides two law student scholarships in recognition of his parents, the late attorney P. Scott Neville Sr. and Miss Alice D. Nevels. Life member of the National Bar Association, a member of the Cook County and Illinois State Bar Association.
Bar ratings.
This is ratings.
Bar ratings.
This is a rating, folks. Let's do the ratings.
Right. The Chicago Bar Association, highly qualified. The Cook County Bar Association, highly qualified. Illinois State Bar Association, highly qualified. Puerto Rican Bar Association, highly qualified. The Hispanic Association of Lawyers, highly qualified.
And there's one I didn't get a chance to put on there, the Chicago Council of Lawyers. It says well qualified.
Beautiful.
Or very qualified.
Well,
but the people need to know in his personal life, he is a father of two daughters, and he's married to a powerful woman, and he loves his brothers and his sisters, his family. You know, he looks to serve, but then this man is a family man. He's a father. He's a husband. He's a mentor. A lot of people he loves, and that's very important.
Let me say, Justice. This gentleman over here is a pastor of high standards.
He is.
He does not, mince words. And, he talks about what is now, what is happening right now, and what's needed right now. That's why I'm so connected to that church, because of that kind of attitude. When you see preachers who are doing other things other than building or trying to build or trying to pull the community together, pull the people together, when you see that, it just doesn't bother me. I'm a minister for the last, how many years? 20 years. So about 20 years, a little over 20 years. But, I really couldn't find where I wanted to be until Anthony decided to come back to Chicago, and he left Berwyn. He almost got sued by the people in Berwyn, and you know who was in Berwyn. They sued him because he didn't want him to leave. You can't leave us. Really?
It's a true story.
and it took the heads of the church to come down and talk him out of it, because they did not want him to leave. So that's who we're dealing with here now. We're dealing with a gentleman of high standards in the law industry and high standards in the church industry.
Right.
So let's get to it.
His work proceeds.
Justice, can you give, we need to be educated in terms of what this means, particularly to black Illinoisans. If I'm correct, you just said the late
Charles Freeman
passed
died today. Passed today. Today.
Now, he was the first black person elected.
Right. Took 172 years.
172 years.
From 1818 until 1990. 172 years to get an African American on the Illinois Supreme Court. And we've had an African American on that court for the last 30 years. Justice Freeman from January of 1990 through June 14th of 2018, and I've been on the court from June 15th, 2018 to the present. But for 30 years, we've occupied that office. Our voices have been heard.
And WL, that's why it's important, so important as people are looking at this programming today. And I just want to say to everybody, we can't throw away this kind of history because he's qualified. Let's say that too, because I don't want people to get confused. The justice is overqualified. He really needs to be on the United States Supreme Court, but that's another story. We'll get there if we got to go there. But the thing is that we cannot throw away this kind of distinguished history in terms of a man whose body of work
Yeah, and he may not look it, but he's still a young man too.
Correct.
And you like you said, there's a possibility for the U.S. Supreme Court in the very near future.
There's a possibility. That could happen. Could be God's will.
You come to Illinois and pick one of the justices.
Right.
He's one of the best.
That's right.
Well, so, I concur with you, but I think we'd be remiss if we didn't acknowledge the work of my predecessor, Charles Freeman.
Oh,
yes,
man.
sir.
Great judge, great jurist, who authored a number of very important decisions. But more than that, and I just looked at it today, Justice Freeman is responsible for diversifying the Illinois courts. Since Justice Freeman took his seat on the Supreme Court, 16 African Americans have served on the appellate court. 11 of those African Americans Justice Freeman appointed. 11 of the 16. That's somewhere around 68%. The number of people he put on the circuit court, they're just too numerous to mention. But I know the numbers far exceed 5 or 6 times the number of people he appointed to the appellate court. So I think he leaves a legacy of being a great jurist in terms of his body of legal decisions. But also, he did more than any other Supreme Court justice to diversify the Illinois courts. And it was not only just blacks, he also placed a number of Jewish judges on the court. He was an equal opportunity
Right.
appointer. So we cannot overlook that.
I think that we should mimic that.
I
As close
think,
as
and
we
I think
possibly
you're
can.
right. Well, in terms of that, I've been on the court 20 months. I've appointed 4 men, 4 women, 4 blacks, 4 whites, and 1 gay judge.
This judge or justice.
No, judge. They're all circuit court
Circuit
judges.
court judge, right.
Now, and we need to address that for a minute. The 4 African Americans that I appointed countywide. They are now running for election. Their names are Lloyd Brooks, Celestia Mage, Cherie Henry, and Lavander Smith. The voters should vote for them. Because you see, if I make appointments and then my appointments don't remain on the court, then we're not going to have the bench that I'm trying to develop once I leave the court.
Yes, sir.
See, I have a succession plan.
Right.
I'm trying to put people on the court because I recognize I will not always be there.
Right.
But I'm trying to put people on the court who can possibly succeed me.
And I don't see you losing the election at all. I do not see it in my spirit.
Well, I hope your spirit is correct. I'm working as hard as I can to make that happen.
And the law affects us every day of our lives. And then when people a lot of times get caught up in the system for various reasons or don't have the proper representation, then they get angry at the law. You know, would you in just kind of common sense lay terms explain us in the audience in terms of why it's so important, particularly for black folks to understand the importance of the law and that this is a nation of laws?
That's true, not men. Well, let me begin by saying the Civil Rights Amendment gave us the right to vote. How many lives were lost and how much blood was shed so that people could exercise the franchise and vote?
Right.
We live in a state where citizens, ordinary citizens, get to vote and select the people who sit in judgment of them. Now, are we going to ignore the lost lives of our forefathers? Are we going to get up and go vote? Early voting's taking place right now from the 2nd of March through the 16th, and March 17th is election day. You certainly have enough time during the next 15 days
Yes,
to go vote.
To go vote.
Your right to vote is like a lottery ticket, but you can't win if you don't play. But as Reverend Williams said, you do not have a right to complain if the day after the election you don't vote and you go to court and get a decision that you don't like. That's your fault.
Yes, sir.
You could have changed that decision. You know, a lot of people talk about the Laquan McDonald case, but the trial judge was voted in by the citizens of Cook County. Get up and go vote. You have the right to vote. Exercise it. You have a right to vote for the circuit court judges. There are 2 seats open on the appellate court. One is my seat, and there's 1 seat open on the Supreme Court. But we have a seat on the Supreme Court. Let's keep the seat. Why should we give up the seat? Let's keep the seat.
Because the only thing I can see is that many people in the race against you, per se, is going to do nothing but split the vote, and we lose that seat forever.
You're
We'll
right.
lose that seat forever.
We lost the mayor's seat for 32 years.
Yes.
When 2 African Americans ran against each other.
Right.
Tim Evans and Sawyer. And we were out of that office for 32 years until last year when Mayor Lori Lightfoot won the election. 32 years. We were not in the mayor's office on the 5th floor. This is a very consequential election. We're at a crossroads in this country. The New York Times reports that courts are facing a crisis of legitimacy, state courts, state Supreme Courts. And the crisis of legitimacy exists because over 40% of the people in the United States are people of color. But there are 23 states in the United States that don't have a person of color on the state Supreme Court. There are 13 state Supreme Courts that have never had a person of color. It's my considered opinion, since over 60% of the people in Cook County, and it's only Cook County that is electing a Supreme Court justice, if over 60% of the people are people of color, we have a right to have a person of color on the Supreme Court. And of course, I think that person should be me. Punch 116. That's a vote for you.
Judge,
That's great. That's great.
Judge, the Illinois Supreme Court, for the audience, that's the highest court in the land,
The
correct?
highest court in the state of
In the state of
Illinois,
Illinois.
not in the
I mean,
land.
I
in
mean the state of Illinois, rather, right.
Yes.
What does that mean? What does that mean to the average lay person?
That means that no decision made by a circuit court or an appellate court in Illinois, the final word is the Illinois Supreme Court, unless that court goes to the United States Supreme Court. We are the court of last resort in the state of Illinois. Only 118 people have served on the Supreme Court in the court's 200-year history. Justice Thomas in the 2nd District just retired, and he named another man to replace him or fill his vacancy. So I was the 117th, and Justice Burke is now the 118th judge to serve. But only 2 of those 118 have been African American in 202 years. 2 African Americans.
Wow.
Let's keep the seat.
Let me ask you something. Who were, in terms of the great legal minds, who were some of your role models?
That's a good question. Well, an American to serve on the United States Supreme Court.
Right.
Great civil rights lawyer who argued numerous cases before the United States Supreme Court. And he went to the Supreme Court and became the great dissenter, which is why it's so important to have an African American on the Illinois Supreme Court, because I bring a perspective that no one else has. I bring a Bronzeville perspective.
Right.
I was born in Bronzeville. I was nurtured in Bronzeville. I was educated in Bronzeville. I was socialized in Bronzeville. And I developed my judicial philosophy based on my experiences in Bronzeville. Martin Luther King said the moral arc of the universe bends towards justice. My moral arc also bends towards justice, and it's tethered. I'm going to repeat that. It is tethered or guided by the due process and equal protection provisions of the 14th Amendment, a civil rights amendment.
Right.
Remember, the 14th Amendment provides that no person shall be deprived of life, liberty, or property without due process of law, nor deprived of equal protection of the laws. That's what I intend to do, to ensure that no voice is unseen, no person is unseen, and no voice is unheard, because I believe in equal protection of the laws.
Right. Well, something like, talk about the Supreme Court, talk about the United States government, I should say. There is a law within the federal law that forbids certain things from happening to the citizens of the United States, but we overlook it. We just overlook the state, the U.S. laws.
You're right, but let me go back to one point. He asked me who were my great legal minds.
Right.
I could not fail to mention R. Eugene Pinchot.
All right. can't.
R. Eugene Pincham was a legal superstar in the state of Illinois, a lawyer's lawyer.
Yeah, I was going to say wizard.
He was a wizard, had natural legal ability. And he was one of my mentors. You know, I wrote a statement today mentioning Justice Freeman's death. And I point out that my legal career was guided by three wise men, all jurists. First was Justice Glenn T. Johnson, the man that gave me my first job as a law clerk on the Illinois Appellate Court, and I became the first African American man to clerk for an appellate court justice. The second was Justice R. Eugene Pincham, my mentor, who brought me into a number of cases. I have worked with Justice Pincham, and he and I advised the legislators that promulgated the sub-circuit legislation. The sub-circuit legislation was important because after the law went into effect and the county was divided into 15 sub-circuits, enough African American and Latino judges were elected so that Tim Evans in 2000, 9 years later, became the chief judge, and he's been the chief judge for the last 20 years. It just shows you the connection between Justice Freeman's work, Justice Pincham's work, advising the sub-circuit legislators, and what happens in the legal community. Tim Evans becomes the chief judge. As a result of the sub-circuit legislation, I then co-founded the Alliance of Bar Associations so that lawyers were treated fairly and equitably because of a diverse evaluation system.
Right.
The Asian American Bar Association, the Hispanic lawyers, the Puerto Rican lawyers, black women lawyers, white women lawyers, the Decalogue Society, the Chicago Council of Lawyers, the Cook County Bar Association, the Illinois State Bar Association, a diverse group of bar associations that I refer to as the United Nations of Bar Associations. And those bar associations make it possible so if a woman wants to be evaluated for a judgeship, she does not go before an all-male group.
Right.
Black women lawyers are there, as well as the white women lawyers, and then the lawyers who are part of the other associations, the female attorneys. It is a black lawyer does not go before an all-white group. You have the Cook County Bar, you have BWLA. They are represented. A Hispanic lawyer does not go before an all-white group. You have the Puerto Rican Bar Association and the Hispanic Association of Lawyers. Jewish lawyers, they have the Decalogue Society and the Chicago Council of Lawyers. Greek lawyers have the Hellenic Bar Association. It's a United Nations of Bar Associations.
Wow.
And this was my idea about making the system fair. You see, I have changed the legal system. I didn't think it was fair for a lawyer to have to appear before the Chicago Bar Association, which did not admit African Americans until 1966. So they don't make the exclusive decision about who is going to sit on the circuit court. In fact, once I was elevated to the Supreme Court and sworn in, I called a meeting of the Alliance and the Chicago Bar, and I told the Chicago Bar they could only evaluate or vet my appointees to the court if they were sitting with the Alliance. So they got a different perspective than theirs.
Well, see, you have vision,
Yes.
and lots of us don't have the vision, so we are left behind, or we are making mistakes. We're doing stupid things, and you know what I'm talking about.
Yes, but let me also say this. You know, you talk about vision. When I joined the court, I discovered that over 70% of all litigants are self-represented. Reverend Williams, you know that adage. A man who represents himself has a fool for a client.
That's right.
Now, these people are not representing themselves because they're fools. They're representing themselves because they can't afford to hire a lawyer.
Right.
So I made a proposal, and it's in the Chicago Sun-Times editorial. They point out that I came up with the idea to give lawyers continuing legal education credit if they represent a self-represented litigant. Here's how it works. If a lawyer will give a self-represented litigant 5 hours of legal service, he'll get 1 hour of credit. The maximum number of credits you can get is 6, but you have to do 30 hours of work on a self-represented litigant's case. So that's how I'm trying to get people to use the courts more. I mean, if you go into court and the other side has a lawyer and you're there by yourself, it's not a fair fight.
Right.
And the whole purpose of the due process clause, notice and hearing, you cannot have a hearing, a meaningful hearing, unless you have a lawyer. That's my view. But that's not the only thing I proposed. I also proposed that they put recording devices in all civil courtrooms throughout the state. Tim Evans sent me a report and told me there are 195 civil courtrooms in Cook County. In the remainder of the state, there are about 200 courtrooms. Okay? 200 plus 195 is 395. Let's round it off to 400 courtrooms.
Right.
I made the recommendation on June 15, 2018 when I was sworn in. I can report to your listening audience tonight that they now have recording devices in the eviction courtrooms in the Daly Center. What's the purpose of a recording device? A recording device is important because if you do not have a transcript or which reports what took place each time you went to court, you lose your appeal.
Right.
So that's a meaningless right if you cannot effectuate your appeal rights. So now that they have courtroom or recording devices in the eviction courtrooms, if you want to appeal an eviction case when you lose it, you can go get a transcript. Either have somebody type it or send the disc up to the appellate court so that the appellate court knows what's going on. But you see, these are just two small ways that a citizen should have not just the justice he can afford, but he should get the justice that he deserves.
Right. Absolutely. You know, I had a case, a friend of mine had a case in a courtroom of child support.
Okay.
Child support. Listen to this. The child that they're supporting is in college. He's 20-something years old. And, you know, he had told his wife, his ex-wife, they had separated, got a divorce. He told her, it's okay, I'll pay half of his tuition, you pay half of his tuition. They made that suggestion. He lost his job, so he didn't have money to pay him. He asked me to go to court with him. I went to court with him. And he was trying to explain to the judge. He said, shut up, I don't want to hear what you got to say. Female judge. That's ridiculous, you know. But I told Tim about it. Yeah, she was kind of rough. Rough, nothing.
Well, but you see, what would be so helpful is with that recording device in the courtroom,
Yes,
it would have,
yes.
all of that would have been
Would have been
recorded.
recorded.
And if you go and complain to somebody, you have an actual recording.
And that's absolutely right. That's absolutely right. That's the greatest thing that the courtroom could have. It's something that would keep a judge level-headed.
Well, if they're not, then there's a recording of it.
Yeah, yeah.
We're going to take a little break. We'll be right back after these messages.
Now, let me just tell you what happened with that.
you following me?
Why my hoodie make me look suspicious?
Why does my music make me dangerous?
Why are people that are supposed to protect me attacking me?
Why are you afraid of me? Why do you think I'm dangerous?
Why do I afraid of people who are supposed to protect me?
Why can't I make a peace sign without you labeling a gang sign?
Why does standing your ground only work when I'm on the ground?
Why do you show this photo over this one?
Why do you only stop and frisk me?
Why do you have low expectations for me?
Why can't I run down the street without causing alarms?
Why do you think I'm a thug?
Why do you assume I'm armed?
Why can I breathe?
Why is my mom scared every time I leave the house?
Why are you targeting me?
Why am I a target?
Why?
Why? I know why.
And it has to stop.
It must stop.
Because I have dreams.
Because I can change the world.
Because I will make a difference.
Because I have a family.
Because I am strong.
Because I'm talented.
I have a voice.
I can find a cure.
I have goals.
I can lead the country.
I am determined.
I have a future.
Because I'm a scholar.
I am powerful.
I'm someone's friend.
I'm someone's brother.
I'm someone's son.
Someone loves me.
And because my life matters too.
My life matters.
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 All lives matter.
And so did theirs.
What's it like working with your family? Good question.
Right, great question. Original Soul Vegetarian was established over 38 years ago from our parents, so we're second generation owners.
Back then in the 80s, nobody knew what vegan looked like.
But if you say, oh, this is barbecue, they'll eat it and say, oh, it's good.
Original Soul Vegetarian has been an anchor in this community. At least 90% of our clientele aren't vegans.
It has helped the community a lot with being aware of healthy eating and healthier options.
Most of everything that we sell is sourced locally, and it's all made in-house because it's just not about food for us. Your health is your wealth. Just add something healthy to what you're eating. You're gonna feel better.
Tropical World. Come to Golden's Tropical World for tropical fish of all sizes, colors, and types, and other small animals like iguanas and birds from all over the world. There are beautiful tanks, pet supply needs, including dog and cat foods, and expert consultation. Check out Golden's Tropical World, 8611 South Ashland Avenue, Chicago, Illinois. Call ahead, 773-239-8809. Your pet shop. Okay, we're back, and we have our Justice of the Supreme Court of Illinois here with us, talking about the evils of evil.
Are you supporting him?
I support him 150,000 times.
You endorsing him?
I endorse him as many times as I can. I'll even put an X as many times as I can in that voting box.
No,
if it was legal. If it was legal.
The people of Illinois need to realize the importance of having someone with this type of not only body of work, but my discernment is his commitment and sincerity for what's best for the people of the state of Illinois.
And he's had a year and a half to prove that, to show that
Correct.
commitment.
And that's something that the Tribune said.
Right.
They said, we thought he was a good appointment, and his time on the court has demonstrated that that was a good pick by the Supreme Court.
Right, right.
So the Tribune concurs with you. I'm sure they don't often concur with you. They concur with that comment.
Well, you know, I'm basically true. You know, I don't beat around the bush like a lot of talk show hosts do, and try and spook the people, have the people thinking that they have a chance to elect a mayor. I mean, not mayor, a president. They don't have a chance to elect a president. The president is already approved, he's already appointed, he's already elected. When they tell him you're the candidate.
But the people can maintain this great man, Justice Neville's, at the Illinois Supreme Court level.
Because it's still local.
It's local, and
all politics are local,
and that's what moves the needle.
That's right.
That's what moves the needle for people. And people don't understand. You know, people take it. No, don't you ever, as long as you're a citizen in America, understand the importance of your legal system. He's here because the needle was moved legally.
Right.
He's sitting in that position because Thurgood Marshall,
R. Eugene
Pincham, and other unknown soldiers moved the needle.
That's right.
King moved the needle for him to sit there. Fannie Lou Hammond moved the needle. So we just can't. This is history, and seniority is very important. And oftentimes in our community, I've seen us throw seniority away. We cannot afford, WL, to lose Justice Neville from this bench. We cannot throw this experience and seniority away. Can't throw that away. That's unintelligible.
Well, let me say this. You know, you continued to point out how important the judiciary is, and what the listening audience should understand is you're more likely to come in contact with a judge than you are with an alderman, a state representative or a state senator, or the governor, a congressional person or a United States senator or the president. You more than likely, during the course of your lifetime, will have to go to traffic court, you or a family. You might go to divorce court, you, ladies and gentlemen. As I pointed out, you have the right to select the people who sit in judgment of you. That's a great power. That vote is power that you can exercise. Don't give up your right to make the decision about who sits in judgment of you. But also keep in mind, ladies and gentlemen, that I'm your servant. You pay my salary. I work for you.
Wow.
I work for you.
Hey, I can't wait to vote. I'm doing early voting.
I work for you. I am your servant there working for you, trying to keep the scales of justice balanced. If you come to my chambers, you see a lot of scales. And I'm trying to keep those scales balanced so that the court system works for everybody. I want people to feel comfortable when they come to court. That's why I, like Justice Freeman, am trying to diversify the bench. Remember, I said I appointed 4 men, 4 women, 4 blacks, 4 whites, 1 gay judge. I am trying to keep the scales of justice balanced so that everybody feels comfortable in our courtrooms. That's the way it should be. That's what the founders intended, that everybody was going to be treated equally in the eyes of the law. And that's what I will ensure happens. You know, one thing that might be helpful is to talk about a case. Reverend Williams has continued to mention my body of work. There are 2 cases that I consider to be very important. First case is the case of People versus Dimitri Buffer. Mr. Buffer was a 16-year-old juvenile. Mr. Buffer, unfortunately, committed a very horrific crime. Mr. Buffer killed someone, but he was only 16. Mr. Buffer's case presented the question of whether or not a sentence of 50 years is a de facto life sentence. The court reviewed that question, and we decided that if a juvenile, a person who's younger than 18, if that person receives a sentence or has a sentence imposed that exceeds 40 years, that sentence is a de facto life sentence that violates the Eighth Amendment to the United States Constitution. Why is the Buffer case so important? Why is it a landmark case? Because 128 people, most of them black and brown, will have their sentences revisited. I'm going to repeat that. 128 juveniles, most of them black and brown, will have their sentences revisited.
Wow.
That is a landmark case. I had lunch a couple of weeks ago with the Appellate Lawyers Association. They invited the Supreme Court justices to have lunch with them. I was sitting with 3 assistant attorney generals, people that work for Kwame Raoul, our attorney general. They told me that the assistant attorney generals took a vote and they considered People versus Buffer to be the most important criminal case they worked on in 2019. So I consider it to be a landmark case because of the number of people who will be affected. They also considered it to be the most important case that they worked on. But not only People versus Buffer, I consider my dissent in the Van Dyke case to be a very important and significant case for me and the African American community. Just to remind the readers, Mr. Officer Van Dyke was the police officer who shot and killed Laquan McDonald. As a matter of fact, he fired 16 shots at Mr.
Not at him, in him.
Well, he fired his weapon 16 times, and Mr. McDonald was hit 16 times.
Yes.
Mr. Van Dyke was convicted. He was convicted of second-degree murder and aggravated battery with a firearm. In 2004, the Illinois Supreme Court was presented with a case very much like Mr. Van Dyke's case. Mr. Lee was convicted of aggravated battery with a firearm and second-degree murder. The Supreme Court had to decide which was the more serious offense, aggravated battery with a firearm or second-degree murder. The Supreme Court concluded that aggravated battery with a firearm was the more serious offense. Why did they come to that conclusion? The range of sentence for second-degree murder is 2 to 20. The range of sentence for aggravated battery with a firearm is 6 to 30. You can see 6 to 30 is a more serious offense than 2 to 20. Unfortunately, the trial judge in the Van Dyke case did not follow Lee. Lee said, you vacate the less serious offense, second-degree murder, and sentence on the greater offense, the aggravated battery with a firearm. In the Van Dyke case, the trial judge vacated the aggravated battery with a firearm and sentenced on the second-degree murder. My position in Van Dyke was very clear. We have a precedent. People v. Lee. We're not following Lee. You're following the dissent. The dissent was not the majority in Lee. It was the majority in Lee said aggravated battery with a firearm is the more serious offense. That was my simple argument. The problem that the Lee case presented was, if you sentence on Mr. Van Dyke on aggravated battery with a firearm, the minimum sentence he could get was 6 years. The problem was he was convicted of 16 counts of aggravated battery with a firearm. 6 times 16 is 96. That was the problem. I, like Justice Pincham, feel that we have significant cases that I worked on. One, my majority decision in Buffer, my dissent in Van Dyke. Now notice, Thurgood Marshall was a great dissenter. R. Eugene Pinchot was a great dissenter on the Illinois Appellate Court. I am following in the footsteps of those two legal giants. I have been the greatest dissenter during my era on the Supreme Court. I have reversed more convictions and filed more dissents than any justice sitting on the appellate court.
And Judge, Du Bois said at the beginning of the 20th century, towards the end of the 19th century, he said going into the 20th century that color would be the #1 problem of the 20th century. And all the great cases were around key issues of color.
You're absolutely correct.
Now, in the 21st century, I'm saying that violence is the #1 problem of the 21st century. That's why I shared with you about HR 0433. Violence is a health crisis and a disease. Because once you are finally properly elected, you're re-elected, you're running for re-election.
Well, I'm running to be elected.
You're running to be elected.
Right.
To be elected, and this would be a permanent seat, right?
Right.
Somehow I feel and I discern that you as a legalist would begin to see the violence for the system that it is. See, I don't talk about gun violence. I talk about the system of violence. It's a system. At the core of it is mental illness. So the suggestion, the legislation that we're trying to pass, comprehensive legislation on violence is a health crisis and a disease, but there must be a wraparound with this that impacts the public policies as well as the judicial system. So I'm tossing that out to you because you know better than I. It's law. It's the needle was moved by way of the law. That's why we began to look at violence in terms of getting some legislation around it that will have impact on laws.
Well, I think you're right that there is a crisis. I think that mental health has a lot to do with it. But beyond that, I'm not going to comment on your bill because your bill could come before the court as to whether or not it's constitutional.
Yes, sir.
And I don't want to have to recuse myself. But
you understand?
I understand,
right,
and I think that it is something that the society needs to deal with.
We had to have a solution. The law brings forth Lisa Hernandez, Camille Lilly, and LaShawn Ford.
Okay.
So I just wanted to just share that with you again because this creates a different type of legal paradigm even for you all with the existence of such a bill to come.
Yes, you're absolutely.
So that'll be new frontier for you.
Yeah, it will. Well, it's a new frontier for the society.
Yes,
We're trying to change the paradigm.
Yes, sir. Yes, sir. Yes, sir.
Well, guys, well, it's the first time I hate to cut the show off because
it's a great show. We must go out and vote.
Punch 162.
That's right. That's right.
Punch 162. That's a vote for you.
That's right.
Let's keep the seat.
Let's keep the seat.
I almost said punch 162 or I will punch you.
No violence, W. No violence.
I said almost.
Punch 162. That's a vote for you.
Right. Let's make history, you all. This is a history-making moment. You may not think it, but this is a history-making moment, and let's be a part of history.
Punch 162. Punch 162. That's a vote.
162.
162.
Closing remark, guys.
Well, WL is honored, to be here and represent Avalon Park Church, 8100 South Dante, Chicago. People are always invited out, but to be with this distinguished Justice Neville, this is something in my lifetime I remember. I'm humbled. He has a Muhammad Ali type of spirit. The confidence is there to get the job done, and I'm very proud of him. To see and to sit here with him, it does me so well just to see the sincerity, but also the ability that he has and the compassion that he has.
Well, he's an individual who has pretty small positions, elected positions. So I lead this ward. I lead this area. You don't lead nothing. You represent those people who are paying your salary.
Yeah.
Right?
You're absolutely correct. Well, let me just say this. It was an honor to be here again with you, WL. During my 20-year judicial career, you've always been very supportive. And I had the pleasure and honor of meeting Reverend Williams. And I'm just waiting and watching to see the great work that he's going to do for the city and state. And maybe he's going to reform the entire country. And let me close by saying this. Just keep in mind, my name is P. Scott Neville, Jr. I am the 117th and second African American to sit on the Illinois Supreme Court in its 200-year history. As W.L. Lillard said, I am your servant. I am a public servant. It has been a high honor for me to serve the people of Cook County for the last 20 years. And I hope that you will go out and punch 162, because that's a vote for you. Let's keep the seat.
Punch 162?
Punch 162.
We'll see you this time again tomorrow. Same time, same station. Good night.